Good evening, everybody, and welcome to the Goffstown Zoning Board meeting of January 4th, 2022. I'm surprised I remembered to say that. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. The Goffstown Zoning Board is an elected board of 5 members and up to 5 appointed alternates. Currently, the board does have 5 members and 1 alternate, so if anybody is interested in serving on the ZBA, please contact Town Hall Zoning Office. The board has a posted agenda for each meeting and tends to follow the items in order. The board will open the public hearing on an application to receive testimony from the applicants, the abutters, and the affected parties, and also to ask questions about the request. The public hearing will then be closed and the board will enter into a deliberative session to discuss the merits of the appeal. For each application, the board will decide to approve with conditions, deny, or continue to a later meeting. You're welcome to watch the deliberations tonight, or you can contact Town Hall to get the results. For an applicant's request to be approved, there must be an affirmative vote of at least 3 members. An applicant can request a continuance if there is not a full 5-member board to act on an application. If you are aggrieved by a decision made by the ZBA tonight, you have the right to appeal to the Superior Court. However, before appealing to the Superior Court, you must request a rehearing with this board to preserve your right to appeal. Rehearing requests must be filed within 30 days of the decision and state all reasons why the decision was unlawful or unreasonable. And failure to request a rehearing may forfeit your ability to appeal to Superior Court. And I'm going to ask everybody to be sure your phones are silenced, and I'm going to ask the board to introduce themselves, and we'll start with Patty.
Patty Gale, staff.
Jason Cody, member.
Leonard Stewart, Vice Chairman.
Gail Lebrecht, Chair.
Alan Yaten, member.
Judy Elaine, member.
Thank you. And tonight, one of our regular members is absent, but we have an alternate here, so we do have a full 5-member board. Judy, you're going to be a voting alternate all night.
Yes, ma'am.
Denise will not be here tonight. Okay, and so I guess our next step is the minutes to the meeting of December 7th. And I've already made note of what Jason had said earlier about the sentence on page 7 that needs to be deleted. And are there any other corrections?
I didn't see anything else.
Okay, do we have a motion?
Motion to accept the minutes.
Okay, do we have a second?
I'll second.
And all in favor?
Aye.
Aye.
Aye. Motion carries.
I'll abstain on that, Gail, because I was not present for the last meeting,
You weren't?
December 7th.
Oh, okay, all right. So it's 4-0 to 1, Leonard's abstaining. All right. So the motion carries. Minutes are approved.
Is there a spare copy of the agenda somewhere?
Pardon?
Yep.
Is there a spare copy of the agenda? Thanks. Mine apparently is on the kitchen table. Thank you so much.
Okay, our first application for tonight is a public hearing on remand by the Housing Appeals Board of the ZBA's finding regarding unnecessary hardship and their denial of the use variance for the following application. And when that hearing is done, the ZBA will also be holding a public hearing on the variance request regarding setbacks. Hemley Investments LLC, owners applicants, are seeking 2 variance requests. The first request is to allow a proposed multifamily use in the commercial industrial flex zone. The second request is to permit the proposed 30-unit condominium development that will have 4 buildings with less than the 1/2 the building length to the side setbacks. This concerns section 3.11A3 and section 4.4.1.3 of the Goffstown zoning ordinance. The properties are located at 134 Mast Road, map 5, lots 54 and 54-1, zoned commercial industrial flex. And this was continued from December, November, and October, or something like that?
Been continued a couple times, that's correct.
Yes, okay, so, but we are all here, so that's a good thing. So what do you want to tell us about your application? Or first introduce yourself,
Okay.
please.
Daniel Muller from Cronin Bisson and Zelinski on behalf of the applicant Hemley Investments LLC. Based on the presentation, I'll first address the hardship for the use variance because it appears that that's the way the agenda is sort of set forth, that we're going to deal with that issue first, and then I'll, if necessary, discuss the setback variance. The discrete issue that is left with respect to the use variance is the one of hardship. And our hardship argument, as the board is well aware, back in 2011, the legislature amended the state statute relative to variances to provide two alternative definitions of hardship. One, which is actually the second one in the statute, basically asks whether due...
I didn't get that. Could you try it?
Sorry about that. The dangers of technology, I will put the watch over there so it does not think I am talking to it again. The second and more restrictive one basically asks whether you are effectively denied any reasonable use of the property. We are not arguing a hardship under that statute or that definition. We are arguing a hardship under the first definition, the so-called simplex standard, which was intended to be less restrictive and focuses on whether, owing to special conditions of the property, you're essentially denied a reasonable use of the property. I'm assuming that the board has seen the order from the Housing Appeals Board. They went through and identified a number of special conditions of the property. It is our position that those conditions make the proposed multifamily use a reasonable use of the property. More specifically, as sort of outlined in the Housing Appeals Board decision, the zoning district here allows for mixed-use development. If you look at this from a practical perspective from the street, there is commercial next door that will be interconnected with this residential. So from a street perspective, this will look exactly like what is permitted within the commercial zoning district. In fact, the Housing Appeals Board went so far to note that indeed, if these had been merged, this would have been permitted as a matter of right. The Supreme Court has indicated that that sort of notion, are you trying to do essentially what is permitted, goes to whether the use, or the proposed use, is reasonable. So from our perspective, and I would also note here that in terms of density, we're not trying to maximize the density. There's a proposal for 30 units. We're not trying to get the absolute max here. This is below the max. So given that we're trying to do a lesser density and trying to do something that at least in terms of spirit fits within what is allowed within that zoning district, we think that this is a permitted, or not permitted use, a reasonable use of the property, and that the special conditions, such as the fact that you already had a road to interconnect the two that was approved by the planning board back in 2009, that you have, regardless of the title issue, that there is a rail trail that sort of bisects this property and pushes the majority of the developable land to the back. Whereas with a purely commercial use, you're going to want to be as close to particularly Mass Road as possible for things such as signage and the like for commercial uses. All of those factors make that this particular proposal for this particular property, and the only other thing I will probably add to this is that the one parcel next door is already done for non-residential. The property to the other side, which is in the zone, is for utility. My memory of some of the minutes from beforehand is a concern that this is going to establish a precedent for this area of the zone, but this is a different property than many of the other properties. Most properties do not have an established commercial use with a proposed access road that would interconnect with the next door property, that's with that property also being next to utilities. There's just no other place. You can't put residences behind it. Again, that's utility. You can't put to that side, it's utility, and it's our non-residential to this one side. I believe that a lot of the properties across the way are in a different zoning district, but again, for this zoning district, that's the focus. So for those reasons, we think that hardship should be found. If the board desires, I can move on to the setback issue, but I will leave that up to the board as to how procedurally it wants to address the two requests.
Board, do you want to go on to the next, or do you want to address this first?
I'd like to address one at a time.
Okay.
Yeah,
And
if
I
that's
think that's a
possible.
good idea.
As I said initially on this, I think the use is the threshold issue, and after that, we should look at the setback.
Okay, that's what we'll do. So does anyone have any questions of the applicant? Alan?
Could you be more specific and short, like bullet points? What are the special conditions of this property as it relates to this development?
As it relates to this development, give me a moment and I will get you the bullet points, because I think actually the Housing Appeals Board did it for me, so rather than going through, I will hit it. You have the size of the parcel at 4.88 acres. There is a rail trail that bisects it, such that any commercial development would have a front setback issue. Residential uses do not require a view of the main road, as many commercial uses do. You also have wetlands and topography issues to the parcel. I'll call it the Langley parcel to the one side, and you will have power lines to the other side, which also make it such that further residential development in the area is highly unlikely to occur. So all of those conditions, which the Housing Appeals Board found were special conditions of this property, make it such that, and the only other thing I would note is that there is also a previously approved interconnection between this and the Langley property. That was when they initially went through in 2009, there was a road that was allowed to go up that way. And that distinguishes it also from others in the area such that you will have an interconnected development in the end, one way or the other. So when you're talking mixed-use development in this zone, which is residential plus commercial, that's what you will see from the road. You know, again, you'll have residential and interconnected commercial because of the conditions of the property.
Was there anything specific in the, did you get an easement from the Langleys? And is there anything specific in the language of those easement, that easement, that allows or prohibits anything?
Number one, my initial response, I'll have to check, but easement issues are technically out. I'll have to put this on the record, so I preserve the issue. I'm going to answer your question, but number one, easement issues of that nature are outside the board's jurisdiction under the Short versus Town of Rye case. But I can ask if there is an easement already in place, or if there was discussion that I would have to check on. The easement would have to be negotiated, so the answer to your question is, they would be getting the easement, but that was something that was,
So there's no easement, is this, right now?
that's my understanding, correct.
Then how can you state that there's an easement?
There was a road that was contemplated to serve both properties. That was done back during the 2009 developments.
And that road has an easement, or you have an easement for that?
We're going to get an easement over
No,
that.
they're
My
gonna
understanding is
get
they've already had
Going.
discussions.
So you're still, okay,
Wait
so
a second,
you're
give me a
going
moment,
to
please.
get.
Have something to bring
Yeah, me too.
after you. Please, ladies first. What's going on?
I hate when they tell the truth and not all.
Again, I will reiterate that in 2009, the planning board, when it approved the interconnected development of the two properties, approved this road. It is on the, my understanding is on the plans for the development, and it just simply needs to be built. And it was contemplated that, yes, they would go, Emily would access its property from that easement road when it was approved back in 2009.
So the road was approved, and you're gonna need an easement from that road to get to the property.
It would be in the nature of an easement over the road unless it became a public road, correct?
Okay,
I,
I see.
I,
And
if
go ahead.
I may, Gail, if I recall testimony from the previous hearing, Denise Langley indicated that the public portion of that road, Tatro Drive, stops at the cul-de-sac
Yeah.
in front of the construction building, so it's private road beyond that point.
Okay.
I might also add that I was on the planning board when this project was approved prior.
Okay.
You know, I mean, it's one thing I'd like to take exception to council's description a little while ago of the area as residential plus commercial. Because I'm looking at the definition of the CIFZ 2.3.9 of the ordinance. CIFZ established to provide for larger scale business parks, commercial service, light industries, similar usage. I'll skip some of the rest of the verbiage and you get to the very last sentence of that section. Mixed residential uses also are allowed. Clearly, commercial is the primary intent of the CIFZ.
If I can clarify, I believe my earlier statement was I believe properties across the street are in a residential zoning district. I wasn't talking about this district. I did say in this district, mixed-use development is permitted as a matter of right.
All right. Thank you, council.
Jason?
All right, so looking at what you just brought up there, as well as some of the things that you brought back up, one of my concerns about this is that right now this property doesn't exist, and you're relying on the fact that the Langley property is commercial, so your residential units make it mixed use. I feel that doing that now kind of hand ties the Langleys if they ever wanted to change their property to something else. They kind of lose that right, because now you've got all the residential and they've got all the commercial. It doesn't seem fair, and it doesn't seem to be in the spirit of what we're trying to do here. But that being said, if we were to assume that we were moving forward with this again, there's now some other things that you brought up back up, which kind of leads to safety. I would be hesitant to vote for anything until I see traffic study on Mass Road. Because, and even though it's standardly or traditionally part of the planning board, you're asking us to make exceptions to a CIFZ. So we have to take a look at how that's gonna affect the rest of that zone. And I feel that with now all of the residential properties that are being developed on the other side, that at the time I wasn't aware of because I wasn't on the board. Now that I've been made aware of this and I am a member of the board, I kind of have to say, well, we're introducing traffic across the street. We're introducing traffic on Bog Road now for another development that was going on for many years. And now you're asking us to make an exception for your zone, for your lot. I think in order for us to be able to understand, I think understanding the traffic impact of that development does have bearing on this now.
May I respond? Number one, I think the safety and the traffic thing was raised with regard to the public interest and spirit of the ordinance claims. In fact, whether there's a threat to public health, safety, and welfare is part of the consideration for those elements. Those elements are not before you anymore. The board, the Housing Appeals Board, reverses board with respect to those elements.
Madam Chair, can I respond to that?
Sure.
So I was unfortunately going to have to let that go, but you brought this up back when you said that we were talking about the rail trail. And then it was highly unlikely that there was going to be any other further residential development. And you brought up the interconnection between the properties. So I think you've reintroduced the safety issue because now we're talking about interconnect.
I will respectfully disagree. These issues were addressed the first time this was here, and this is, again, if you read the Housing Appeals Board order, the issue before this board on remand with respect to the use variance is very limited. They reversed you on a number of things. I don't think you can suddenly go and say, try to expand what you can do. They have appellate jurisdiction over this board. They made a decision. No one appealed that decision to the New Hampshire Supreme Court, which is if somebody disliked what they did, that's where you go. They reversed on those issues. The question was whether there were special conditions of this property that made it different, such that that use could be deemed reasonable. And I don't think that gives you, that opens up every other element and every other consideration again, because in that case there was no point to going up to the Housing Appeals Board and getting their particular order, because it would mean that everything was back open yet again. And that's not what their order says. So I have to respectfully disagree. And to be candid with you, I would expect that once we go to the planning board, yes.
That's
We
what I
are
was gonna
going
say.
to
He's right.
end up probably having to do various studies. I'm certain that they'll look, I remember the last time, there was a concern about access from Mr. Yeaton. I'm certain that they will revisit that issue. I'm certain they'll visit the issue of traffic. I am just trying to keep it focused on that particular issue with respect to the use.
Yeah, just the hardship issue is what we're addressing for this tonight.
I think though that we were told, I think, that this could be something that the zoning board could address, which is why I wrote it down. Because the safety component of this is very important to me.
Yeah, oh, I understand that. Alan?
On page 4 of the remand notice, we got from our attorney, page 4,
from the attorney's letter?
Yep.
Our attorney's letter?
Yep. In the first highlighted paragraph here, there's a note here that says, fourth, unique to this parcel is the access through the Langley commercial developed parcel, which they don't have.
Yeah, well, I was looking at the same thing here, in the Housing Appeals Board statement, and because they said, well, I lost it. They also referenced it having an easement. And I think it's an assumption that they made that was obviously not accurate. Here it is. On page, well, it's not,
That's how it was presented.
page 8 of 9. And it says, we'll use an easement reserved for access to the site through a commercial development. So
Doesn't exist.
it doesn't exist.
And can I add one other thing too?
Sure.
But before tonight, this is the first time that I heard utility being used as a measure of the other properties. So,
That's okay.
yeah, well, but it adds to, like, this is more information of the thing that was supposed to be remanded that changes information. So I'm
But
kind of stuck here.
the utilities are related to the hardship criteria, whereas the just traffic study is not. That's something that the planning board will do, and that's something that they usually do.
Okay.
I can't say they will, I will say they usually do a traffic study.
Okay. I'll just listen further for now.
Okay. And one of my concerns with this, and I gotta find all my little notes here, if I can. No, that's not it. Is that in the hardship criteria, where is it? I lost my document.
I know that feeling.
Yeah. In the hardship criteria, it was, one of the portions of it is that the, let's see, no? No, that's the applicant's, I think. I'm gonna have to go by memory, so I'm gonna stumble over my words here, and hopefully I'll get my understanding, or my thoughts out there well enough. But in the hardship criteria, one of the things is the purpose of the zoning ordinance. And the purpose of the zoning ordinance for the CIFZ, as Len referred to earlier, is to maintain the ability to have some commercial and industrial property in here. And yes, there's concern on my part that this would set a precedent for others in the CIFC zone to want to do just residential. But the CIFZ zone, and I am not introducing the master plan as a reason, but as to get a better understanding of the purpose of the CIZ zone, and above and beyond, let's see, where is it? What Len said earlier, because I'm going to read the whole thing, if I can find it, there we go. Established to provide for larger scale business parks, commercial service, light industries, and similar uses in areas where access is available from arterial or collector streets. The CIFZ district is intended to encourage commercial, industrial, and service uses to the mutual advantage of both consumers and merchants, thus promoting public convenience and prosperity. Mixed residential, non-residential uses are allowed. And when the CIFZ zone was created back in 2000 and 4 or 5, because it was on the ballot in 2005 and approved to adopt the town zoning ordinance, the 114A corridor management plan, adding a new definition and amending the district by changing the zoning maps, implementing Route 114A corridor management plan for the Mass Road corridor, so that it would be oh goodness. And so the master plan, when it was updated in 2006, it says that if nothing further is done, and this was regarding the this was in one of the summaries on page 1B19. But anyway, it says, in fact, if nothing further is done to guide where and when what type of development occurs, the remaining undeveloped land in Goffstown will gradually be built out with new housing. If not balanced with commensurate amount of commercial and industrial development, these new houses will likely result in an increased tax rate. Without a suitable supply of vacant land services by utilities, few commercial or industrial businesses will locate to the town other than highway-related strip development. So one of the intents for having the CIFZ zone was to have the commercial and the industrial there, so that it would help offset the taxes. And that is important to Goffstown. The Goffstown voters voted it in, and it's been something trying to maintain all along. And I think that's the purpose of the CIFZ, and that this type of development goes against, because it is not the intent of the CIFZ, I don't believe, is to have an area that is mixed use of this lot is residential and this lot is commercial. But each lot as it's developed is supposed to be that mixed use. That's the intent. And so I have a big problem. I'm just very concerned about that, about preserving our conservation and industrial properties, because we've got so few lots left available. So I wish I had my paper so I could say it in better words, but that is what I've got for now.
Well, if I may follow up on your remarks, Gail, I'm also troubled by the language of the order, which creates, quote, an area of mixed-use development. The way this thing apparently was presented to the Housing Appeals Board, the easement and the interconnections and all of this were presented as fait accompli, as it's referred to in the decision here, and it doesn't exist at this point. I'm troubled by that we're being asked to approve this, and I concur with Gail's remarks insofar as I think the requirements, we're being asked to zone an area. We're not being asked to act on the individual lots cited in the decision. This extends into affecting the Langley property as well. So I'm troubled by all of these aspects of the way this was presented.
If I can respond. Number one, with respect to the order, the town was represented during that hearing. That is an adversarial hearing. Again, the Housing Appeals Board made a decision based on arguments from both sides. And if this board or the town did not like the decision, its obligation was to appeal to the New Hampshire Supreme Court. There is no ability to go back and redo the order at this point in time. It is, speaking of fait accompli, it is fait accompli at this point in time. It is final. It is binding. In terms of the other argument, I actually see the opposite of what you're saying. I see the board taking a position that this is, essentially would argue that use variances are not permitted in the CFIZ because master plan, which there are weaknesses and there are problems with relying on the master plan. The master plan is intended for a guidance for your other regulations. It's not in and of itself something that you can enforce. And the argument here is that this particular lot, because of its circumstances, you want commercial development? I have a sewer easement. There's a rail trail towards the front of this. If I'm going to do commercial development like you want, that's a problem because I'm going to have to push back from the road, which is where my patrons would see me and where I want to be, close to the road so you can see whatever I'm doing. With a sewer easement already in place, which is in the application, which was referenced, and regardless of the title issue and the rights to the rail trail, as a factual matter, it is there. And it bifurcates and limits the use of the front portion of that property for things such as a commercial use. So in this particular lot, and that's what our focus is on this lot. I'm not saying generally in every place, but I'm focusing on this lot. This lot had circumstances, and we're arguing based on those circumstances, and that's why I also disagree that there's an issue of precedent. The whole point of variances is you look at the circumstances of that property, and whether there are circumstances here, such as the fact that the front portion is encumbered, where you would normally want your commercial or non-residential development. Whether there is, because you're concerned that this will become an area of housing, whether in this section of the zone, can the other lots around this, if you put a residential development here, if this is utility land over here, it's not going over there in the future, not going over there, or up here where there's also the same utility land. This is developed. I understand your concern about potential future uses, but at this point in time, that's developed and that's pure speculation as to what if they want to change something one day. Well, the town may decide to change the zoning one day. I can't focus on what may happen one day. I'm focusing on what's happening here and now, which is I have a lot whose front, if you look at the plan, is you either have rail trail or you have sewer easement right in the front. If you look at the plan, there is not a whole lot of space right along that frontage that's going to be able to be available for commercial space. So again, now some of the arguments I'm hearing here come a little close to what the Supreme Court rejected in Malachi Glen, which is essentially I want to reject a variance for the very reasons that it sought, i.e., I'm looking for use variance. I'm not telling you I'm looking for a permitted use. I am arguing that if you look at this use from the street perspective, and this is what the Housing Appeals Board found, this will look like your mixed-use development. Under your statute, or under your ordinance, I do not have to have, for example, what they have in some parts of Manchester where you have first floor commercial and then have to have residential above. You can have separate residential building and then separate commercial building. So from my perspective and what we're arguing here, again, this particular piece of property, because of its circumstances, in its circumstances alone, I'm not arguing for rezoning. You're not the board who does rezoning. We understand that. That would be for the selectmen and for the town, ultimately for the voters in the town if we wanted to do rezoning. But what I am hearing and what I am concerned about is this is essentially an argument that's being presented forward that now, because you're going for a use variance to allow this multifamily to be next to this commercial development, can't get it, which to me is problematic legally. So I understand what you've said. I still think under the law that there is a hardship here. Because I do think that given the fact that I can't use that front thing and I would have to push things back, that it may not be the best property for commercial here. And it's certainly not the size of the property next door where you would, you know, you could put a myriad of roads through it. It's just not that large where you're going to do something like that. So, again, for those reasons, we think that it meets the hardship test under the Simplex standard.
The variance criteria says, owing to special conditions of the property, which you've addressed, and I agree that they are special conditions of the property, that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, and this is the part that catches my attention, no fair and substantial relationship exists between the general public purposes of the ordinance provision, because the public purposes of that I addressed earlier, as far as the commercial and industrial use, and specific application of that provision to the property. So I was just wondering if you could elaborate on that then.
Sure. That, again, that entire definition was essentially taken from the Simplex case, which was decided in 2001. The Supreme Court, in cases following, essentially construed those basic requirements. And there's a case called Rancourt versus City of Manchester, where they said, under this new Simplex test, the question isn't whether owing to special conditions of the property, you are denied a reasonable use of your property by the zoning ordinance. That used to be under a series of cases that began with one called Gray Rocks. That used to be the hardship standard. So if you had a reasonable use under the zoning ordinance, technically you could not meet the hardship standard. They found that to be too difficult to meet. In Rancourt, they said under this new one, which is much more friendly to property rights, the question is whether, owing to special conditions of the property, the proposed use will be a reasonable use of the property. And going back to, if you want to put it broadly in terms of what you're discussing, I don't think anyone here debates that mixed-use development is allowed in this zoning district. While we talk a lot about the commercial and industrial, mixed-use development is allowed in there. And I think our argument has been from the beginning, and there is, again, Housing Appeals Board went this way, looked at it too. If you look at that from the street, if these properties were one property, it looks just like what you permit in that zone.
But they're not.
I
And that's my
understand
point.
that.
That's my point.
But the question is, as a matter of spirit, is that what it goes to? Yes. And that's what, when you talk about purposes and things like that, if it goes to the spirit of the thing, yes, that's what a variance is for. Because every variance, by its very nature, is not going to meet the terms of the zoning ordinance. I mean, if you say, this has been the problem, and this was the problem in Malachi Glen, the one I cited earlier, where you can't deny a variance for the very reason it's sought. The reason is, every variance by its very nature is going to be somewhat inconsistent with the purposes. So if you look at that in that light, which is, I'm sorry, I think that's what the board is doing, you could never grant a variance, period. Because variances by definition, because they are a variance from the literal terms of the zoning ordinance, they just cannot meet that standard in any case. And I think it's getting too, once you start to say, you know, this is it. You know, either you know, are commercial industrial or you can't do anything, then there's no point to seeking a variance ever because you'll never get it. And again, I think that you're supposed to look at the particulars of the property.
Okay. Jason?
I also guess though, using that same logic, and I guess this is just a comment, but I'm trying to work this out in my brain, but using that same logic, a variance should never be denied. Like, I think you could see it both ways. So I'm trying to process this, you know what I mean? I'm trying to understand this in my own mind.
Well-
I've got some questions now that I think I need to address to our attorney. So I want to bring that up. I don't know how we deal with that, but I think we need to do a continuance so I can talk to the attorney.
I don't know that that would happen.
Sure, Ken.
Well, it could, but to talk with our attorney, we'd need to get approval of the town administrator. It's not just something we can just go off and do.
Okay, so then we would need to do a continuance so that we can figure out if we can do that. Because now I can't make a decision because I have information that I don't know how to process. And I'm not trained to do that.
I don't know that we should continue it, only because the applicant has had so many continuations already.
But that wasn't our fault necessarily.
Well, it was the board's fault. Well, it was because the board was short-staffed, or short.
Handed.
But there was
yes.
enough to make a decision and they chose that as well. So
But they had the right not to. They took their right not to.
I'm not
So I don't want to
disagreeing with that.
penalize them for using an option that was given to them.
Okay, I don't know. I mean, I guess I pose this to the board, but I don't feel I can make a decision on this without
Do you
information.
want to discuss it now, or in deliberations? Because after we start deliberations, we could continue it if we can't come to a conclusion. But I mean, I certainly wouldn't stop it now.
Okay. No, I wasn't saying we could stop it now, but I just was bringing this up.
But I also think that the applicant needs an answer.
I guess I don't agree.
Maybe, I
I mean,
mean,
I do agree, but I don't agree.
right, no. I would rather not continue because of what they've already waited upon. But, you know, let's play it out and see what happens. You might get some answers,
Absolutely.
and maybe you won't, but we'll find out,
Okay.
okay?
Can I ask a question?
Mhm.
You had brought up permitted use versus something else, and I didn't get a chance to finish writing my notes.
Hold on, I wrote it. What's permitted use versus, wait a minute, where is it? Oh, no. Yeah. Approved road easement.
I'd be happy to
Yeah, go ahead.
bring up the various points.
It's just that one specific.
With respect to permitted uses, obviously the mixed-use development is a permitted use in the zoning district. But I think what you were looking for is permitted versus reasonable use, and that's comes from the hardship definition.
Right,
Reasonable use is not necessarily a permitted use, though permitted uses by definition are reasonable uses.
Yeah, I knew there was an important reason why I wrote it down. It had to do with the
I
hardship.
got half of it written, and
so-
then I couldn't remember what the other half was.
Thank you.
You're welcome.
Okay. Alan, did you have your hand up?
Is there anybody from the public here wishing to speak in references? I'd like to hear from them if there's anybody here.
Well, hold on, let's see if the board has any more questions, comments.
I'm not at this time.
Judy, questions or comments?
None.
Okay.
Just for a point of order, if you do deliberate, and he makes a motion to continue to get legal opinion, you'd have to reopen the public hearing.
Right. Okay, so we will open I would suggest not moving just yet. I'm going to open the hearing to the public if there's anybody who has comments that they want to make. And I'm seeing none, so I'm going to close the public hearing for now.
Thank you for saying for now. I don't think you want to close it yet. Because he can't respond.
Who can't respond?
The applicant can't respond if you close the public hearing.
Okay. So I'll just take that part back. Okay, so what does the board think?
Madam?
Yes? Now your hand's up.
This is an interesting case.
Mm-hmm.
There's a lot of conjecture and statements and evidence, and some of which we've heard is true, and some of which we heard is not true.
Mm-hmm.
And that puts me to a point where I think we need to consult with the attorney to find out whether, and what we should do, and whether we should really act on anything that the appeal board said, period. Other than what would be our normal practice. We're here, we're hearing it again, conclude it with a vote and a decision. But before we make that decision, vote and decision, I think we need counsel here so that we can ask questions in executive session,
Non-public session.
non-public session. I'm not ready to vote, I'm not ready to entertain a motion at all.
You weren't here last month because we did have that meeting with the attorney beforehand, with the opportunity to ask
Oh,
questions.
I was here.
Were you? Oh, it was you that weren't here?
Yeah, I was.
I'm sorry.
I was absent.
was here.
Okay, okay. So you're requesting another one.
Well, reality, some of the statements he even made in his correspondence is based upon evidence that doesn't exist.
The easement?
The easement, for
Yeah,
one.
yeah, that bothers me.
And so to be quite honest with you, I want to read him the Riot Act.
Who?
Wake up and smell the roses, town attorney.
Well,
I think you can request that to the town administrator, if you need a legal opinion.
go ahead.
I think both Alan and Jason raise some questions, and I think there is, in point of fact, and we can agree to disagree, counsel, on the use of fait accompli, but at this point, if the information that was presented to the appeals board, particularly in regard to whether this easement exists or not, I am not sure that our attorney would have gone to the extent of verifying with counsel or with the opposing side whether that easement existed, for one, or would have known that going into the appeals board hearing. I think that's a factual question that needs to be answered. And
We could probably get that without an actual meeting,
To ask him, you can ask.
because Derek would submit the question to him.
Yeah, you can do that. Or you can continue to get more input, you can do what, you have that right to do that.
Yeah,
I mean, I know we have the right to, and I certainly don't want to hurry it, but at the same time, if we could come up with a resolution or an understanding, it would be, I just hate to see one more continuance for the applicant. But on the other hand, it's this. Yes,
Can I just make one point on the whole access issue, which I've now heard quite a bit about? I would remind the board that Ms. Langley was and did testify in this case. they are the person who would have said, if there is an objection to this access road that's being proposed, I'm sure she would have raised it during the public hearing when she testified in favor of this variance. If you look back at your records, you will see that she did indeed testify in this case. She is the abutting property owner, or her LLC is the abutting property owner. She was the principal. She came here, she testified. The plans were all there, including the showing of the access road that is now being made into something, again, I don't even think is within the board's jurisdiction under the Short versus Town of Rye case. But that issue, which now appears to be growing and growing, I will remind the board that that has been there from the beginning, and there was never a suggestion that there was an objection to that, or that wasn't what was contemplated when they went back for the initial interconnected development. There was no suggestion to the contrary, and there was plenty of opportunity to do so. So I will simply make that remark because, again, I think we're starting to get a little bit of field.
My concern is that the term easement is, when I first heard the term easement as it relates to this, was in this paperwork. It wasn't before, but there is no easement, you've said that. And the decision of the Housing Appeals Board was based on an assumption or erroneous facts that there was an easement, and there is not.
Whether there's an easement, a license, whatever term
But
you want.
the
question is it understood that there is a right to go over, that they are going to use that access road to get to the property? Yes, there is. That, it was understood back in 2009. It was understood when this was filed. Again, that, you want to focus on the nomenclature, whether it's an easement, a license, whether it's agreed to access way,
The easement, their assumption that it was an easement is what they used to join the two lots, or to connect the two lots, so to speak, as a commercial industrial flex, or meeting the purposes of the commercial industrial flex. There is no easement that is now doing that.
You don't have to have an easement per se. I could have a license and do the same thing. The question is whether there's a legitimate question as to whether there could be access over the Langley property, and as I said, she testified in this case. If somebody wants to point out testimony where she said that that was not going to be the case, that they had objected to it, I will stand corrected. But my memory of the records here, your minutes, doesn't reflect that. And again, that's just my viewpoint on it. I think it is game far afield and could end up outside the board's jurisdiction. That's all I am saying. And the issue of easements and the like come up frequently. Most boards require you to, as a condition of approval, you provide an easement for water, an easement for sewer, an easement for this. That's all done after the fact. And then that's, I guess I'm going to leave it at that at this point.
Jason?
So I want to make something clear. So for me, and I can't speak for everyone else, but for me, I don't have an opinion yet one way or the other on the access road piece. My concern is specifically the Mass Road entrance that you have here and how the traffic impact is now, like, we're introducing residential specific part of this CIFZ where this information didn't exist before. in terms of how we're changing this environment. Okay, so that's, I wanna make it clear, my issue isn't the access road piece right now. I haven't even thought about that piece. I'm more thinking about the Mass Road side of things. Now, that, of course, does introduce the fact that Mass Road is only entrancing and exiting one side of it, like, north, was it southbound? I can't remember which way it is, but, so the other entryway is by the Shell station. So, that kind of brings everything together, I guess, a little bit. But the other question that I had is, how many variances have been requested for this property? Like, for the property, not, like, not, have I was kind of made aware that there have been other variances requested for this and other approvals that were done?
There was a site plan presented for a commercial building on that site.
That was years ago, and it's really kind of a moot point at this point.
Oh, okay.
It's a whole different application. Nothing's been granted for us, by us.
Oh,
from
okay,
this-
all right.
It
For this
didn't go,
application.
it didn't go to the zoning board.
Ah, okay, I thought I had heard that, and I was like,
No, it
well,
did
I
not
didn't
go
know
to the
that
zoning
either.
board. It went to the planning board.
Okay, all right, so that answered that question. But I still, I still feel that we need to address some of this with our attorney. Because otherwise, if you're gonna force me into a decision, then, I don't know how I can vote. So,
Well, you could vote yay, nay, or abstain. I'm not gonna force a vote. Do you want to take a straw poll on?
No.
Or a regular vote on whether we,
Can't take a straw poll.
So let me throw one last question out into the ether on this, which is, I'm not going to attempt to define legal terms, but the question is, do favorable testimony and verbal promises constitute an easement under the law? You know, again, I think it's the question of whether it requires an executed legal document
Yes.
or whether the verbal assurances
Yeah.
are enough.
I'm concerned that prior to tonight, there had been no easement. There still isn't. But yet, the decision from the Housing Board of Appeals reflects their understanding that there was an easement. That's my biggest concern right now.
I concur.
so, when we first talked about this and before this went to the appeals board and everything, we were requested for the appeal, right? And you and I had voted that we thought it would be appropriate to make sure our I's and T's were dotted. This is the same thing, just from our side now, is I want to make sure I understand the legal stuff that we're talking about here. And, with no respect to you, sir, but I
no
need to hear from,
disrespect.
no disrespect, but I need to,
Either way, no offense taken.
I need to hear from our attorney, because ultimately, if this goes back to some kind of appeal of some sort, he's going to have to work with this, and I need to understand that I'm not doing something incorrectly.
All right, well, does somebody want to make a motion to that effect?
Can't make a motion, you haven't closed the public hearing.
I can close the public hearing if somebody wants to make the motion. I just want to make sure the conversation is depleted.
We can continue the public hearing
We
to a
can.
date certain,
Mhm. It would be next month.
and then, in the meantime, we can request a consult with our attorney.
Well, I concur with Gail because there's no clarification between the appeals board, the New Hampshire Housing Board, on the easement. and then it comes over. So one says it is and it isn't. So
Well-
the clarity, something has to be cleared
Well-
up. As Len said, life doesn't work on verbal agreements in
No,
this
no.
category.
And I think
Doesn't
that it's,
revolve around speech. You can say anything,
Right,
but to make it true, it has to be legal.
correct.
And it's not legal,
And Gail said it.
period.
and I think it's an important answer to have because it seems to
It
me
is.
on the basis of presumption of the easement, the housing board lumped the Langley property and the applicant's property into an area, de facto area of mixed use. Again, I think that's the vital question to answer.
But
It is,
we're very knowledgeable of things, but none of us were asked to be at the hearing or to speak in behalf of the town. We were not consulted by the town attorney before it went to the appeals board at all. So
well, I see.
that's what I have a problem with.
I see two options then, right now. I see that we could continue this and pending a meeting with, or a discussion, or getting questions answered by the attorney one way or the other. Or voting on it. If we vote against, I'm going to presume there would be an appeal to the housing board, and then they would know about the issue with the inconsistency regarding the easement.
I don't
But
know
then
if-
the housing board, well,
I don't know if it goes back, what the appeal process is for
the,
the Housing Appeals Board, but I think it's the Supreme Court.
no, they have the option of going to Supreme Court if they want, but Supreme Court takes longer. And so applicants have the opportunity to go to the Housing Board of Appeals first if they'd like. And then if we could have appealed the Housing Board's appeal, or they could have if they didn't like the decision, and then it would have gone to Superior Court. Is that correct?
Now, here's the instance. The only reason it went to the Housing Appeals Board is because it's presented as a housing project. It would not have gone there if it didn't contain housing, if it was a commercial development and they couldn't get their variances. It would have to be appealed to the Superior Court and then to the Supreme Court of the state of New Hampshire.
Yes.
Did you want to answer to your prior question?
Did I want, yes.
Okay. The process, and again, I won't take offense because I know I'm not your attorney, but the process would be if you made a decision, I didn't like that decision, I would first file a motion for rehearing with this board.
Right.
Then I could have the option of either appealing to the Housing Appeals Board or to the Superior Court. If I did not like, or if the town did not like their decision, then the appeal would be to the New Hampshire Supreme Court.
So housing appeals doesn't go to Superior Court after that? It goes
No.
to Superior, okay,
It's,
thank you.
It only hears, as Member Eaton just indicated, it only hears complaints dealing with housing issues. The Superior Court can hear both housing and commercial/industrial.
Gotcha,
But it's an option at this point in time.
okay. All right, so what does the board want to do? Okay. I think I'm going to close the public hearing. So the board can decide what they're going to do and take a vote.
Well, you can continue the public hearing without closing the public hearing. You don't want to close it if you want to continue it. Because now you have to reopen it again.
We can do that.
I don't know which is, I don't know which is the easiest.
If we just, I mean, if we're going to reopen this next month, if we,
If you continue it, you don't have to renotice it.
right,
That's the only difference, I believe. I'm not
yes,
sure.
yes, it would, in the end, if we continued this, it would all be continued, and there's no renotice, because it goes on the record right here and now.
Yeah.
And it would still be subject to public hearing then as well.
Yes. I would prefer a continuance, especially if we're seeking more information before making a decision.
Is that a motion?
I didn't say a motion.
No, not yet.
Then I'll make it a motion to continue to a date certain, which would be February,
February 4th? Is it?
I put all the meetings
Oh,
in
I have
my
it here.
calendar.
I have it here.
February 1st.
February 1st, really? Wow. Okay, so Alan's motion to continue to February 1st pending,
All it has to do is a motion to continue.
yeah.
What we decide to do is our response.
Do we have a second?
I second that.
And all in favor?
Aye.
Aye.
Any against? We will continue one more time. So this is continued, this meeting will be continued till February 1st, and we will, it does not require public notice. This is public notice for all of those that are
Can I just ask as a courtesy if I could call in to see, in the event that you decide to go to council and council cannot meet with you in time for the next hearing, if someone could just advise us of that. That's my only request,
Yes.
because
Yes.
I know Attorney
Everybody's
Sturgis,
busy.
I know his schedule, so that's my only request.
no problem.
Yeah.
Thank you.
And I'm sorry it's taken another month.
Thank you very much for hearing me tonight. Again,
Thank you.
Thank you.
Okay. I'm going to, I need to take a break for a couple minutes. You want to start getting the other applicants going, or do you want to take, do you want to close and take a break?
I think we just, let's do a 5-minute break.
All right, the board's going to take a 5-minute break. We'll come back, it's 8:13, we'll come back in 5 minutes. Welcome back, everybody. And we have our next application, which is for Maurice and Marie Hemond. Is it Hemond or Hemond?
Hemond.
Hemond.
Thank you.
Applicant's owners seeking to modify a use previously allowed by variance in accordance with section 14.6.4 of the Goffstown zoning ordinance. The property received a variance from the ZBA on September 3rd, 1998, allowing the construction of a single-family residence on a lot with insufficient frontage with a condition of approval the lot be limited to 3 bedrooms. The applicant's owners are seeking to increase the number of bedrooms in the existing single-family residence. Section 14.6.4 of the zoning ordinance requires any modification of a use or dimensions established by variance shall require a new application for a variance to be submitted to the ZBA for consideration. The property is located at 16 Surratt Road, map 6, lot 5, zoned agricultural. And if you would introduce yourselves, I would appreciate it.
My name is Morris Hemond. I'm the homeowner at 16 Surratt Road.
Uh-huh.
And I am Robert White of Pasture Drive in Goffstown. I'm Mo's personal friend. I'm also the designer of a subsurface disposal system for the property for the increase of intended use. So if you have any questions.
You're what?
The
Designer?
subsurface designer
Okay.
for the septic system for the
Ah.
property on the increase of intended use.
All right, thank you. All right, why don't you tell us about your application?
So it's as was mentioned, it's a single-family home. We're looking to just add a bedroom for my daughter, who's grown. Her current bedroom doesn't have a closet in it, so we're just thinking.
Is
yeah,
it technically a bedroom without a closet?
That's a good question. That's
I've
a
always
really good
understood that it's
question.
not.
That's what I am understood to believe as well. But
Technically, you do not need a closet in a bedroom.
That's what I've heard.
That's a Supreme Court decision, by the way.
I hear both sides, and I don't
Okay.
know, I'm just a homeowner.
Okay,
So-
but it is what it is.
Yeah, the reality is she has a small room without a closet. She's mature, in her 30s now. So we were looking at our space, thinking we could just do something in the basement. In speaking with individuals, we talked about maybe going ADU, but we heard we could just do a bedroom in the basement, give her a bathroom with it as well. And that's what we're hoping to do. Add a bedroom
And a bath.
and a bath. But I guess the bedroom is the key here, right?
Yes,
Yeah.
yeah.
Yeah. In the basement, that's all we want to do.
Do you have any,
Yeah, the only thing I have to add to this, the property is 2.65 acres. I don't know why the original agreement was, or the original waiver for, or the variance for the 3-bedroom situation. The property is sufficient in size to handle, actually, it's sufficient in size to handle an ADU. And I believe the plan was initially prepared as an ADU and got DES approval for an ADU unit along with the single-family residence.
the plan for the septic?
Yes.
Okay.
It's, I think the issue was at the time is because of being on Surratt Road. In fact, Surratt Road cuts through the property, is actually on the property. And of course, Surratt Road is not a town-accepted road. It's a Class 6 road. And I think that was probably the only issue maybe at the time for the approval and the variance, under the condition that they initially set. A little bit furthermore, the property, like Mo said, he has a grown daughter who happens to be a widow, and that's the reason why she's back at home, living at home. And you know, these are a little bit larger spaces, just to have an 11 by 12, you know, bedroom. The basement would become more of a living quarter for what a bathroom and a bedroom, you know, would be sufficient for what her needs are. They maintain her kind of semi-privacy issue.
Does the board have any questions of the applicant? Are you adding a 4th bedroom or a 5th bedroom?
Fourth.
Because here it says on the request for variance, it says adding a 5th bedroom to a 4-bedroom house.
That's where I get confused as well.
Oh,
Because on the tax plan, it says it's a 4-bedroom house. But on the what do you call it, on this, it says it's a 3-bedroom house. On the original zoning, right, it's listed as a 3-bedroom. It was agreed that it's a 3-bedroom house. Okay, now, on the plan here, I can tell you that we bought a house with 4 bedrooms in 2010.
Does it have 4 bedrooms?
Yeah,
One without the closet.
yes.
You're
Yeah.
including the room
Yeah, yeah.
without the closet,
So you're
saying it's a
asking,
bedroom.
you're asking for 4 bedrooms instead of 3, but you already have 4. So if you're looking to add the 5th, then that would make sense to what's here.
He can't call it a bedroom.
Well, yes, you can.
It has no closet, you said.
Well, that's what I had heard, but Alan says it's not
There's no-
true.
there's no
Oh,
law.
that's not a,
So-
oh, okay.
So it's just a,
So
it's
that
just
has
a,
to do with the,
that's neither
how
here
they
nor there.
add it out, yeah.
It has to do with public housing.
So,
Public
I mean, I
housing, all
just,
except have a-
Public
I can tell you it
housing,
says
yes.
right here, it's, you know, right on our tax thing,
On your
4
tax-
bedrooms, total bedrooms, 4 bedrooms.
I think
Yeah.
when they updated the tax cards, and we have
And-
caught up with the fact that one of the rooms in the house was converted to a bedroom.
Oh,
After the variance was granted in 98, the tax card gets updated in 2010. It was noted at that time, I think probably that one of the rooms in the house had been converted to a
When
bedroom.
did you move into the house?
2010.
That was somewhere between 98 and 2010.
July of
Little
2010.
modifications
Yeah.
took place.
Initially, when the septic plan was prepared, it was based off the tax card, and the state approval is, it's listed as the approval's good for a 4-bedroom house plus a 1.5-bedroom ADU. That's what the state
Wow.
approval is for.
But
So that's fine.
can I just,
Yes, please.
on the actual septic approval, it says it's for a number of bedrooms is 4 on the one from DES. That's on the issue of it, that it was granted on,
This is the approved plan, got the approved stamp by DES.
but the letter that accompanies it on June 14th, 2021, the approval for construction is for 4 bedrooms on their actual, on the lot.
I'd have to take a look at that. Again, this
These
is-
are your plans that you prepared, but
Oh, ouch.
My plan is
these are
prepared-
your plans that you prepared, but the state approval is for 4 bedrooms.
The plan I prepared is right here with the state stamp.
Yeah,
This is
but
the one that
then,
was
just
pulled
let you know,
off.
they say
Yeah.
4 bedrooms, not 5.
So, no, it doesn't say, it says 4-bedroom main house with a 1.5-bedroom ADU. I'd have to go into their website and pull that particular document up. This came off that same file that you've got in your hand, off the DES website.
Yeah, this is what was submitted to the building department. Like the plan reference, it, but not on the, when we get septic approvals, it's for number of bedrooms. And on this one, it says 4 bedrooms.
Yeah, they're not perfect.
8, and it's 825 gallons per. Yeah, that's what we went by, is that the rule. What are you gonna, okay,
Just
I'm
to
So-
hear-
like planning now.
Do you actually need 5 bedrooms or 4 in the house when you're done?
I need the 5th for my daughter. Yeah,
Okay.
I need that for my daughter in the basement.
He has a married son that has a child that lives in the house
Well,
also.
that's
Yes.
So,
Okay.
So technically, there's 3 adults and a child that's living in the house currently.
Which is the same amount of people that were living in the house when we
Excuse me,
bought
4
the house.
adults. 4 adults.
What are you doing with the bedroom without the closet?
Probably just gonna turn it into my office. Because my office was my office, my computer space, my room, it was in the basement that I'm
Giving up.
hoping to give up and just take that room over as my office.
so
Okay.
if
Yeah.
my understanding is correct, this is gonna be listed as a 5-bedroom home. Is that correct? If somebody was to list this home, and then you're saying that the present septic is for a 4-bedroom home. Is that correct from what I'm hearing?
No, 4-bedroom plus a 1.5-bedroom ADU.
Oh, that's what he said, the 1.5 bedroom.
That's correct.
Okay, so it's really
ADU.
5-bedroom house.
That's where I could
Okay.
not.
With a 5.5-bedroom septic.
Yes.
But see,
So
I
he-
disagree
He
with
would be
that.
fine with that.
Go ahead,
That would be
Patty.
fine with it.
All right.
No, it
At
wouldn't.
the bottom of their
No, it
letter,
doesn't.
approval number, see the state septic approval number, the receive date, type of system, tells what it is, number of bedrooms, 4. I'm not looking at his plan that he prepared,
I'll give this.
because they prepare a plan that's for construction, and then they get approval for operation, that's the final sign off on it, and it'll say the number of bedrooms it's approved for.
Here, Patty, you
On this
can,
sheet here.
No, I have no, it's the plan.
you can have this. This is, has the state stamp on it,
Dated.
the approved plan by
Okay.
DES. With the approval number on it. That's what they approved right there.
And it really is an ADU because it has a small kitchen, as shown on the plan, a closet, and a bathroom. So
Yeah.
it really is an ADU.
It's
They
not gonna
they
have,
amended that. They amended the ADU off of it because in order to do that, he also would have to get I'd have to get the special exception. It's not noticed for that. And the impact fees would be involved. And he may need something from the select board because of Surratt Road. So he chose to take out the ADU and come before for increasing bedrooms.
so there's
The
gonna be
applicant talked to Derek.
there's gonna be a refrigerator and a sink.
No stove.
No stove, so it meets the criteria. Let me ask about the bedroom you're putting in. Is this something that is portion going to be below grade, or you're going to have to do like an egress window or
Yes.
anything as
We
part
It's
of
gonna
it?
be below grade.
We have plans to show the egress
Egress
window.
window.
It's already been ordered
Yep,
and ready for installation.
there'll be an
when the
egress
resident gets
window.
here.
I think it's on, I think you have a copy of that.
It's on the plan.
Yeah,
And it'll be inspected, it'll have the own, its own.
Yeah.
Yes, Mark is
Building-
very,
building
I did a
inspections.
project with an egress window, and Mark is very particular about the inspections on them.
Okay. So it is, I guess, I'm still concerned that it's gonna be 5 bedrooms instead of 4, and we're approving only 4.
I was gonna put a clause in, if you guys
No, sure.
did approve this
Mhm.
for 5 bedrooms based on the septic can support 5 bedrooms.
But it wasn't noticed for 5 bedrooms. Does that make it, it's not a big change?
No, I mean,
I don't think it's a,
because
No.
he's
It
asking
only
for that
stated that-
restriction to be taken off for the 3 bedroom.
It only said was, the notice says that it was limited to 3 bedrooms by variance. That's all it says.
oh, that notice, yes, but I'm talking about the notice that went out to abutters.
Should be the
That's the
same
same
one.
notice.
Oh. Oh, I thought you were, I thought that you were looking at the notice from years ago
No.
that the zoning board gave.
It says that it was 3 bedrooms and so it's noticed correctly.
Yep,
Okay.
yep.
It says it was 3 bedrooms, but it's 4.
So?
Shouldn't the documentation be cleared up somewhere along the line? So it's not conflicting, it'll just carry through
Well, I'm
years
sure
later, and
Patty
it's
will make
always,
sure that the
it's always gonna
assessor
be-
knows exactly what's going on.
if it gets in the house.
Sits right next door.
The assessing is what they see, it's not always based on the use.
I know.
But on the actual notice that was posted, it's has Alan stated. It says that was limited to 3 bedrooms, to take that restriction off.
Yeah.
So if, I would say if you were to do it, that you just add, if you proved that it can support 5 bedrooms.
That the septic can
Yeah.
support 5 bedrooms.
And you have a designer that could state, or update it to state it on the approval, the actual front
Do
of
you
it.
happen to know
Even though
if-
the septic, I'm sorry,
Do you happen to know if the records reflect a 4th bedroom being added at any point?
What is, your assessing card is attached to the application. So
It
what
says-
happens is they go out and they assess the property, and they just go by what they see. So if they see it being used as a bedroom, they're gonna say, this is a bedroom. They tell- Even if it, like, they'll go out and find apartments that never came in for a special exception.
Yeah. Well, an assessor's never stepped foot in my house.
The
That's how
tax
you'll
card
prove I'm
says,
making-
the tax
Right.
card says 4
That's what
bedrooms.
I'm saying.
Right on the page 1,
Yeah,
on the total number of bedrooms, in the
4.
list of elements of the house, it says 4 bedrooms.
4 right there.
Yep. So,
Are we tripping over something we don't need to trip over?
that's what I think.
I
I think so.
As long as you state the septic has to support 5 bedrooms, if you have it as 5 bedrooms.
Yep.
I think you guys would be fine for your,
Okay. And he did state he's gonna turn it into an office.
yeah, absolutely.
Okay. All right, I'm okay with it.
And there's a lot of people will have an office in a 3-bedroom or 4-bedroom house. I mean, they could have the assessment changed to reflect, which actually they wouldn't change it, it'd just stay 4 bedrooms. If he thinks it's a 5th bedroom, they just change it to a 5th bedroom.
Well, should we
That's
make
good.
it, should we make any motion just to match the tax card that's in the?
I think you should base it on what he would like. I mean, what he's asking for, because the assessment card can change. If it's.
So are you asking for a 4th bedroom or a 5th bedroom?
I think I'm asking for a 5th bedroom. Yeah, I think I'm asking for.
That 4th bedroom might have, I mean, obviously it was built before you moved in, I'm thinking. So it could have been done,
It could be like it was an office before someone used it as a bedroom, and they went in and said, oh, it's not a bedroom, it's an office, so they didn't assess it that way.
yeah, could be. Okay,
I see a lot of these same situations, especially along Glen Lake, where a lot of these structures were single-family, 1-bedroom units, and in fact, I had a septic design that I did, I went in and it was 5 bedrooms. Tax card shows it as 2 bedrooms type of thing, and then again, vice versa, and I saw actually just recently an issue like with that approval, that letter approval that you got from DES. I actually just did, down in Salem, I just did a system down there where the original approval was for a 3-bedroom. The tax card shows it as a 2-bedroom, and the replacement system was a 3-bedroom size system. But the DES approval said, matched the tax card and said 2-bedroom, but they said, we had a previous approval for a 3-bedroom. Are they downsizing? It was a typographical error, what it was on DES's part, because the original approval was 3-bedroom, and it's always been 3-bedroom.
okay.
I've seen that conflict happen quite a bit.
I'm getting to think counting bedrooms is like counting angels. We're really getting into the
Okay,
weeds
so
of
let's-
something we
let's
don't
jump-
need to worry about.
Let's jump to the meat of the matter, and I'm gonna ask you to review the,
Wait. I have a question not around bedrooms.
okay,
This is a private road or a class 6 road?
Class 6 road.
It's a private road.
Or,
Well,
Yeah.
there's a difference, right?
It's a private road.
Okay, so this private road is on a parcel of property, so are there multiple residences on this parcel of property on the private road?
There's other lots on Surratt Road. He has frontage on Goffstown Back Road, and the kind of like crosses, he crosses over, there's like a little sliver that goes,
Okay.
and it crosses over it, but he does have frontage on Goffstown Back Road.
and much of my Surratt Road, most of it is on my property.
most of the road is on your property?
Oh, yeah.
What did you say?
A good portion of it is on our property.
I know where it
Yeah.
is.
What transpired was that when they wanted to build that house, it had no frontage on a town road. And so they did a lot line adjustment to create frontage for the road.
Right.
That's that site plan that's in there.
Yeah, see, it's.
Where it says
crosses.
And so that made it legal, but then the zoning board in their eminent wisdom limited it to 3 bedrooms. By plan. Why, I have no idea.
Well, and that's the part that I'm trying to figure out. Like, if we're doing this now, would there be a problem? Like, I'm trying to understand why why it was done that way. There had to have been a reason.
Well,
But
They did lots of things
it was different back
differently.
then, different own.
Back in the
zoning
dawn of
ordinances.
time when Alan was here
right,
already.
but it creates a thing where this property was granted the ability to be constructed
Yeah,
because of that. Now we're basically
it's there and it will
Invalidating.
technically support the increase in size and the increase in number of bedrooms
right
and comply with the
with
other
the current zoning.
zoning
Okay, all right, all
setbacks
right.
and all that.
Okay, if you wouldn't mind, where your variance document, where you put in those answers? If you would start with number 1 and explain, you can summarize, you can elaborate, whatever
Oh.
you want, but give me those answers for the record.
For the record,
Yes.
of why a variance is required.
Granting the variance would not be contrary to the public interest because, jump down halfway down the page.
Number
Oh,
one.
okay. Because it doesn't change the outside of the home at all. It doesn't impact anything as far as the outside of the home. So
Okay.
I don't see where it affects.
Okay.
It's all inside.
And how is the spirit of the ordinance observed?
It doesn't affect, again, kind of going along with that, it doesn't change, I think of a variance, I'm thinking, or a zoning, it's with neighbors and others, abutters. It doesn't affect the abutters whatsoever. It doesn't
Okay.
affect them whatsoever.
What about substantial justice?
It would just provide a closet. It would allow us to have a closet in the bedroom.
And values of surrounding properties?
Probably would just add to the value of the house, which
Okay.
would just help the surrounding properties.
Okay. And hardship?
Hardship, I'm trying to write, basically the hardship is, I got a daughter that grew up in our house that got married. 6 months after she was married, her husband died of brain cancer. She moved back home. She was living in Massachusetts. She moved back home. Can I come back home? Of course you can. And she's been home for a couple of years. Of course, we have COVID. She's still living in that little room. Can we do something? Yeah, let's try and do something.
Okay.
So, that's all. Let's try and make a bedroom there.
Okay. Are there any special conditions of the property that make it different from others in the area?
Any special conditions? It's a bigger piece of property.
It's probably the largest, yeah, it's probably, in that whole area, it's probably, other than, obviously, an Allard's property, it's probably the largest piece of property.
Being a larger property, it would hold the added bedroom,
Yeah,
whereas a smaller one might
yeah.
not be right.
And it's a unique configuration.
Yeah, I see
It's
that.
very unique.
It's
Talking about a
yeah.
piece of pie.
Yeah, it is a
Yeah,
pie.
seriously.
When you're looking at the map, I can spot
Yeah.
it.
Okay, does the board have any further questions?
No,
Does,
sorry.
go ahead.
No, I don't. I just realized I didn't say it
Okay,
out
I'm
loud.
going to open the hearing to the public. Anybody back there want to make any comments? There is nobody back there, so I will,
This side.
I will close that public hearing, and the board will enter deliberations.
I'll move no regional impact.
Thank you.
I'll second. Beach it.
All in favor?
Aye.
Motion carries. And how about regarding the application? We want to make sure we word it to include the 5 bedrooms so that, I think, to make sure that it's reflects. Well, do we really need to?
Nope, I don't think so.
No, we don't need to.
You could just remove the restriction. But I think the septic, because you want the front page corrected to say, because that may cause an issue.
Well, I can call DES.
The approval of operation should say 5 bedrooms.
It should reflect exactly what it says on
And
the
it
plan.
doesn't.
You
I'm
know,
just letting
you
you
can
know.
see by that stamp.
Yeah, no,
Yeah.
I see exactly.
So the thing of it is, with the way it's set up there, you have reviewers that do the review of that plan, make the approvals under the conditions that was submitted, stamp it, issue it that approval number for that particular plan, for that type of construction. Then it goes to the administration prepares the final letter,
Yeah,
and obviously they didn't read
Yeah, I would just make sure, because that will
Read it
that'll
exactly
cause an
as
issue
what
in
the,
the building
yeah,
department.
exactly. I'll make a phone call and get them to,
And then if you were to sell, it could cause an issue.
what I'll do is, when I get the revised, you'll get a copy of the revised anyway.
Yeah,
so-
and you'll get
so-
the approval of operation will state it.
So if it does get sold, the septic does cover the 5 bedrooms in the future if anything did
Yeah,
come
or
about
if you were
with
to
that.
refinance,
Yeah.
and they praised it,
Yeah.
and they'd say, hey, this doesn't match.
Yeah.
Okay, do we have a motion?
I'll make a motion to approve the request to increase the number of bedrooms to 5, subject to a corrected DES septic approval system.
Took the words right out of my mouth, Ellen.
DES septic.
I'll second if you're done.
DES septic system approval. Okay, so it's to modify, is it to modify the one of 1998?
Nope.
You don't want to do that?
Nope.
You just want to make to
Just want to make
approve,
it 5 bedrooms.
to approve the variance request to allow 5 bedrooms on this unit,
Yes.
on this lot, this
Yes.
house? Okay, as presented?
To
That's
modify it, though, I think is what you want to do,
Yeah.
because that's how it's noticed.
You're not,
If you look at the way it was written,
No, it doesn't say to modify anything in there.
First sentence.
Request.
seeking to modify a
seeking to
use
modify.
previously allowed by variance.
Yeah, so,
So they're looking to modify that previous decision.
To modify the previous variance.
So by saying we're
Terminology.
modifying that decision, we would be changing it, making that decision moot on that one criteria of their decision.
well, as far as I'm concerned, the motion says you're approved for 5 bedrooms. Period.
Okay. All right, with the corrected DES septic system.
Correct.
Okay, and Len seconded that?
I did.
Alan and Len. Okay, all in favor?
Aye.
Aye.
Anybody against? No. Okay, got it.
Thank you.
Thank you.
You're very welcome.
Thank you very much.
You're welcome.
Can I keep that septic design, or do you want it back?
Oh, it's picture night.
Good thing I printed
Yes,
it out, this thing.
it's picture night, so don't disappear.
I think it says the same thing on the.
I gotta get my hair done.
Adjourning.
Comb your beard, too.
I'll make a motion to adjourn.
Oh, yes,
Yeah,
thank
you want to make sure it's.
Motion to
'cause-
adjourn made by Jason, do we have a second?
Second,
Second.
Oh, I think Len was first.
whatever.
Okay, so we are adjourned at 8:45. Thank you.